Josh Swanson, Vogel Law Firm.
Thank you very much for joining the program here today, the Crude Life, as we talk about this ongoing Wilkinson Mineral Case in the state of North Dakota in the Bakken, which has just been one of those bizarre cases that I didn't know if it would end. And I know there was another court ruling last week, Supreme Court. I'm not sure if it's over yet or if there's going to be maybe a new chapter in this. So we've brought in Josh Swanson. He's the attorney on the case. How are you doing today, Josh?
I'm doing well, Jason. It's always good visiting with you about oil and gas issues, especially the Wilkinson case and the rights of property owners that are impacted by it.
So this case, for those people maybe joining the first time, maybe you've heard of this Wilkinson case and don't know much about it. Maybe you've heard it as the Lake Sakakawea mineral rights, U.S. Corps of Army, U.S. Army Corps of Engineers. You know, there's a lot of buzzwords involved with this different case, but kind of the long and short of it is, and I'm going to give my brief description, then I'm going to hand the baton off to you and elaborate, correct, and kind of go from there. But there was several booms in the state of North Dakota in the 80s and, I don't know, in the 60s or 50s or whatever, and not a lot in between. So there's dormant periods where just things were not being drilled. But that still didn't mean that there wasn't minerals underneath. So when the U.S. Army Corps of Engineers came in to create the Garrison diversion, they flooded some land. And through the course of flooding that land, they took over the surface but did not take over the minerals because the minerals still have value. And the U.S. Army Corps of Engineers was for a public use. It was for a dam. They didn't need that underneath. That was, again, this is my interpretation of what's going on here. Well, then the Bakken boom happened, and the Shale Play USA happened, and $100 oil, and everybody wanted money, and the state got greedy and everything else, and all of a sudden, these minerals, which have never been in dispute before, all of a sudden are in dispute in the court against, you have a private family going up against the king, the state, the government, and that's not easy to do. So that's kind of my interpretation that, you know, these minerals were kind of dormant just because there was no oil being drilled. And then all of a sudden, when there's money to be had and minerals to be had, boy, everybody was coming out of the woodwork wanting these. And the people with the actual certificate of the ownership said, no, it's still us. Now we got to hire an attorney here, Josh Swanson. So, Josh, am I interpreting this loosely enough to kind of have a conversation about it, or is there big key points that I'm missing here?
In a nutshell, Jason, you've got it right. Those are the facts that were at issue. When you say words like dormant, you know, I hate to be the technical legal guy. There's a certain, you know, meaning under Title 38 of the Century Code about dormant land. So you're right. The concept is obviously the minerals were under Lake Sakakawea until we had horizontal drilling. You couldn't get at the minerals, so they were never drilled until the most recent boom up here. But the impacted families like the Wilkinsons had actually been leasing the mineral rights going back to the 1950s and 60s because they're, you know, a lot of those minerals are bordering right on the lake, so some of them were accessible off the shore, obviously, but you're spot on in that the reason this came about, you know, it's that old adage that's as old as time itself, follow the money. These operators come in, they have the technology to access the oil, they start doing it. The market for oil is great during the earlier days of the Bakken boom, and someone at the state decided they wanted a piece of the action for minerals that they never had title to, so that's exactly what they did, and this fight ensued, and we got our favorable decision from the North Dakota Supreme Court late last week.
2008, 2009 is kind of, you know, 12 is when the Bakken really kind of took off and hit its peak, that sort of thing. When did this court case start? When did the state decide that they wanted to challenge the Wilkinsons, or vice versa, whatever it might be?
So based on documents we got during discovery, you know, we served, like any lawsuit, written discovery requests on the state. We do depositions and did quite a number of them in this case. And best we can tell is that sometime in approximately 2009 or 2010, someone It's interesting. It was always once you get caught with your hand in the cookie jar, it's always the not me, it was someone else, and we don't know who decided to do this, and we could never get a straight answer from the state whether it was the previous land commissioner or the attorney general or someone in the attorney general's office who was responsible for concocting this scheme for the state to claim all the minerals. But sometime approximately 2009, 2010 is when they commissioned that first Bartlett and West study under the premise that the state was going to claim ownership to a lot of these minerals under Sakakawea. And then what they did, we know for a fact, in the summer of 2010, they started entering private minerals into the state's leasing database online for companies to put in bids and to lease those minerals. So my clients found out about it, asked, like any other person would, hey, we own these minerals, what are you doing, state, trying to lease them? The state gave them the runaround and told them basically to go pound sand. If you think you own them, file a lawsuit because we're not backing off. So that's what they did. In 2012, the lawsuit was filed, and we've been up to the Supreme Court twice now, and we've gotten favorable decisions from the court both times, and including the most recent one that says, as a matter of law, the state does not own this family's minerals. The state does not own minerals like this family's minerals that were reserved when the United States came in for Garrison Dam and Lake Sakakawea. And more importantly, or as important, I suppose the first two ownership are pretty important as well, but just as important, the Supreme Court said we get to go back now to the district court, just like we had argued, and go after the state for damages for the unconstitutional taking that occurred from when the state first claimed ownership of these minerals about 10 years ago until the Supreme Court's decision. So the risk the state now faces is that there are a lot of mineral owners that could come after them for the unconstitutional taking that's gone on the last 10 years, while the state claimed that they own title to this property and other property like it.
I was going to ask you if there was any precedent being set or any potential precedent being set through this, and it sounds like there at least the potential is there.
Yeah, I think that's a really good observation, and I think the North Dakota Supreme Court, in a unanimous decision, it was a 5-0 decision in the landowner's favor, and we certainly appreciate their diligence and their work on it, and it's a very comprehensive and well-reasoned and well-constructed opinion where it is absolutely precedent setting. It's one of the, I don't just say this because I'm the lawyer on it. I mean, it's some attorneys, it's that old, be the workhorse versus the show horse. Some attorneys would be out there calling themselves, the greatest attorney since Atticus Finch. That's not what I'm doing. The credit for this goes to our clients, but this is, a long way of trying not to be too braggadocious and patting ourselves on the back. This is one of the bigger property rights cases ever decided by the North Dakota Supreme Court, because you have so much land at stake. You have so much value when you're talking mineral rights and impacted people. And this is hundreds of thousands of acres under Lake Sakakawea that were impacted by this decision. So when you talk about precedent setting and the significance of this opinion, I would argue that it's one of the more important decisions involving land rights ever decided by our Supreme Court.
Josh Swanson is our guest, Vogel Law Firm, in the greatest interview, literally the greatest interview we've ever had here. Sorry, I just had to go with your braggadocious. I wrote the word down, braggadocious down. I'm going to use that sometime in the future. Excellent word. So anyway, I also wanted to ask you about, this is, we've been talking about this for 8 years at least. You and I have been, and it sounds like this has been going on for like 10 years. And I know that in the past, one of our interviews, you mentioned that family members have passed away, that certain college graduations have happened. I mean, there's like some considerable, milestones of a family's lineage of time involved here. First question, is this lawsuit now done? Second question, will there be an additional new chapter one as far as damages? Like I mentioned, there was somebody that passed, and you've got, college graduations in the midst there. So talk to me a little bit about, if this is finally done now, and are there conversations about what the next chapter is?
Yeah, there are, and really what happens next is entirely up to the state of North Dakota. The state of North Dakota, whether it's the land board or the attorney general or his office, they could give us a call and we could figure something out. We're open to resolving this. We could do one of two things. We could go back to the district court and have a knockdown drag out, and we can argue that the state is on the hook. There's very, very good and undisputed case law in our favor that says when the government attempts a taking, even if they fail, they have to pay the attorney's fees of the landowner. And that case law, our interpretation of it, it's very black and white. There's no room for gray. The state is on the hook for these folks' attorney's fees. And the other end of it is, you're talking about the potential application of the interest on royalty payments statute at Title 47 of the Century Code. You're talking interest on a judgment, which, you add up the number of years and how interest compounds on top of itself. That could be a good number. For the life of me, what I've never understood about the state of North Dakota, they have refused to talk to us about this. And you know me, and a lot of the listeners out there, chances are some of my clients are out there listening, I'm not a scorched earth kind of guy. I don't go out there beating the drum, looking to take everything to litigation and setting everything on fire like, William Tecumseh Sherman marching through the South back in the closing days of the Civil War. That's not my style. We're very reasonable, and we're open to discussions about getting cases done. I think that's why our clients like us so much and why we do such good work. But, they've never done that. And I don't know that they'll do that here. We've put out the invitations to them through several platforms that they know how to get a hold of us. And if they want to get this done right now, rather than having us go back to the district court, and this case has gotten all kinds of media attention, as you've alluded to, Jason. You've been covering it since day one. The Associated Press has done stories on this, stories about the most recent Supreme Court decision I've seen in places as far away as the Houston Chronicle, in the Washington Times, and all the media outlets, obviously in North Dakota, covering it. And there's even been stories in The Guardian that they've picked up from the AP, and that's over in London. So this story has legs. This isn't a favorable story for the state and what they've put this family through. So what happens next is entirely up to them. If they want to have talks about getting this done, we'll do that. If they don't, we'll go back to the district court, and we feel very good based on what the law is that they're going to have to pay our folks some money. And the other thing that's potentially problematic for the state on this, the state is dragging down industry a little bit on this, because you have oil and gas companies that are a part of this lawsuit, and they've been taken along for this ride almost entirely because of the state's behavior. So I don't imagine that the North Dakota Petroleum Council is too thrilled with how the state has handled this case, and they've filed an amicus brief to the Supreme Court in our case, and my guess is that they would rather see this done sooner rather than later, because it's not something that I suspect they want to be dealing with. So the short answer is that the next step depends entirely on what the state wants to do. We want to have a discussion. If they want to have a discussion, we can sit down, break bread, have a coffee, and maybe hammer this thing out. If they don't, well, Katie bar the door. We'll go to the district court, and we'll see what the court awards us for damages. The other thing I want to touch on briefly, because you mentioned it, family members here have died, several of them during the course of the litigation, and it just breaks my heart. And the reason it breaks my heart is because I've gotten to know these folks over the course of the last decade, and they are such good people. They are salt of the earth North Dakotans. They were born here. They were raised here. Grandma and Grandpa, who originally owned the property, farmed it, going back to the Great Depression and World War II. You had several of their children that fought overseas in World War II, and the daughter. It's something that I think I'll remember for as long as I'm practicing. One of the plaintiffs here, who was the daughter of J.T. and Evelyn Wilkinson, because her two brothers were off fighting the war in Europe, Evelyn Wilkinson, the mom, took her into Williston to get her driver's license when she was like 12 years old because she needed to help on the farm driving truck. And that reminds me about my grandparents and my aunt and uncles and my parents and how they grew up, and my cousins and me, how we would drive truck on the farm when we were like 12 years old and be riding in the combine with Grandpa. So this is something that's been so personal for me for such a long time, because what I see in these clients, I see people I grew up with. I see people I went to church with at North Viking Lutheran Church in Maddock. I see people who came to my high school football or baseball games growing up. I see people who were volunteered as judges for the FFA and 4-H projects, just really, really good people. And for the state, you mentioned earlier in the interview, the state just dragging them through this. And for the last 10 years, I've sat down when they're in town, we'll go out and we'll grab a cold beverage together. We talk on the phone quite a bit, and they, kind of endearingly refer to me as an honorary member of the family, and that's probably one of the greatest compliments I've received practicing law while I've been doing this. But that's something that it's always just been so frustrating to me, that the state has put this family through that, where you've had folks that have passed away and have never been able to enjoy these minerals or their proceeds. And you've got folks that have gone through, college graduations, and this money from these mineral rights could have went to things like paying for college or whatever else. It was their money, and they had a right to use this. So, you're damn right. I'm going to get up on a soapbox about this, because this was such an important decision for so many reasons. But when you have just hardworking folks that didn't ask for litigation, they're not the kind of people. I mean, Jason, being from here, folks in North Dakota don't like rushing off to the courthouse and filing lawsuits, and this hasn't been easy for them. It's been a real difficult 10 years, and the reason why I'm going into a lot of detail on this is I really hope that someone from the state of North Dakota or someone at the Petroleum Council is listening to this interview, and they say enough is enough. Let's reach out to these guys and let's figure something out, and let's get this done, because that should be the next chapter and the last chapter in this saga. I mean, we really shouldn't have to go back to the district court and now fight the state again as to the dollar amount of those damages. There's room to get something done, and I'm really hoping that that's the next step.
I got a couple pure journalism questions for you. The first one is, where's the money? Where's the 10 years of the money been? Has it been sitting in escrow? Has the state been spending it? Obviously, the Wilkinsons haven't gotten it, but does the oil companies keep it? What's happened to the money?
Yep, on that front, fortunately, and this goes back to the state, I think, knowing they were in the wrong on this, rather than using this money toward the school funds like they do with other oil and gas proceeds. It's been in suspense. So the way for the listener to think about it, without going into too much detail, if it's in the SIF fund, which is the Strategic Investment and Improvements Fund, or an escrow with Bank of North Dakota or one of the operators, the money is basically sitting in an escrow-like account, waiting for a determination of the lawsuit here.
So it is there. It just needs the proper keys to be turned the right way to be released.
Yep.
So just to put it in real layman's terms, you need the two Hunt for Red October keys, and it sounds like, Wayne Stenjum is somebody who needs to be a part of that, and this land department, and probably somebody else. It's probably the Bank of North Dakota or something like that. So it's just, and my guess is those meetings are going to be happening if the money hasn't been released to the family at this point. It's that the wheels are in motion.
Yep, and they're actually required. The legislature back in 2017 signed Senate Bill 2134, codifying Chapter 61-33.1 of the Century Code, and that was another important part of the Supreme Court's decision, is that the funds have to be released by the 6-month timeline that now applies, going back to a survey that was approved, the Cattermas-Lee-Jackson, the KLJ survey, which did the acreage determinations, working from the statutory Wenck survey, That was released back on June 25th. So fittingly, by Christmas, December 25th, those funds are required under statute to be released per the Supreme Court's decision.
You mentioned the Petroleum Council earlier. I did want to ask you about the oil companies. I mean, the one thing I have always appreciated about the oil companies is that they're pretty upfront. They're just into results. And, they don't necessarily want to pick sides on a lot of different things. They want to help build communities. But at the end of the day, if there's not money to be made, they generally aren't drilling. And did they take a side on this at all, or did they just kind of stay out of it? I guess did they? They didn't have to because it was a private party against the state. So I can't imagine the oil companies would get too involved on this. But just talk to me a little bit about if they got involved or just where they were through this whole process.
Yeah, by and large, I mean, without getting into the weeds too much, I think it's fair to say by and large, they've been on the side of mineral owners. I mean, the Petroleum Council and their amicus brief filed with the Supreme Court on two of the three big issues sided with the Wilkinson family, which we certainly appreciated. And during the legislative session and the session back in 2017 and again in 2019, the Petroleum Council testified and pushed the bill largely along the same lines as mineral owners. So I don't want to be real critical of them because being a guy who's, dad has several small businesses and coming from that sort of small business background, I get it. I mean, the operators here were put in a real bad position by the state of North Dakota. So they didn't have much of a choice. The state puts the leases up for bid, says they own them. And that happens all the time in situations where you have a title dispute, even not involving the state, where, there's some uncertainty about who owns the minerals. What operators do is they lease both parties because they at the end of the day, they want the lease, and there's a question or uncertainty that's really through no fault of their own, where they lease up both sides and then they let the chips fall where they may. So by and large here, I know there are times where, I sue oil companies regularly. It's not personal, it's business. And when they spill on my client's property, sometimes they accept that and they take responsibility for that. Other times they don't, and we have to drag them into court, which is really a separate issue. But yeah, Jason, I think on this one right here, the operators and the Petroleum Council were by and large on the side of mineral owners. And, we've used the word certainty. They have, mineral owners have. And that's the good thing about this decision is that we finally do have this certainty. But it should never have gotten to this point. I mean, it really shouldn't have. You really have fundamental issues of constitutional and property law, and the state had no basis to claim that they own these minerals. So, we're glad that the Supreme Court issued its decision the way they did, and we hope that the industry will use their considerable sway to maybe lean on the political folks here to help finally push this thing across the finish line.
Well, even the example you gave about taking oil companies to court and when they spill, and to me, it's along the same lines that I was basically trying to point out, that a lot of times oil companies, they're very upfront about their end results. And correct me if I'm wrong, but a lot of times these spills and a lot of the other things, it's the middlemen, it's the service companies that are the ones actually doing the work. The oil companies are just subcontracting the stuff out. And that's generally where it becomes a little bit dicey and a little bit gray and et cetera, et cetera. But at the end of the day, that's why I've always noticed the oil companies, they're pretty upfront about they're just into results. And it was interesting. I was glad to see, I guess, that they were looking more towards the minerals and owners and I guess, that sort of thing. So the Wilkinsons, how are they feeling through all this, I guess?
It was a long day coming. I appreciate that question. They've fought long and hard, and they've really been the champion. There's hundreds, if not thousands, of other mineral owners and property owners that are going to receive money and going to get their minerals back because of the Wilkinsons and their efforts. And I'm proud of them. I'm proud to be their attorney. I'm so very, very happy for them. And I think it's a lot to take in. It's one of those things where even me as an attorney, like I said, I'm glad for the result from the Supreme Court. But it wasn't like I was popping champagne bottles last Thursday. I mean, I had another argument at the Supreme Court actually yesterday, and had other work to get done. So I don't know that it's really sunk in yet when you have a case that you've been that involved in. That's such a big part of your life and such a fight for 10 years, for me and I think them. I don't know that it's entirely set in what they accomplished, what the family achieved through their perseverance and dedication to this cause. And I think over the Labor Day weekend here, sitting around the fire pit with my wife and son and our in-laws and our dogs, having a couple cold Oktoberfest, I think then it might start to sink in a little bit. And I think the same for the family, where we were pretty confident that this day would eventually get here. It just sometimes seems like the light at the end of the tunnel is so far away, but that was kind of our mantra, growing up. Small town North Dakota farm kid is, you just keep plugging away, you keep chipping away, and the metaphor we used was you just keep that sledgehammer and you keep blasting the damn thing against the dam and keep swinging and keep swinging, because that little crack gets bigger and it gets bigger, and eventually the wall tumbles down. So that was kind of our hard hat lunch pail approach throughout all of this, and we're glad for the results. We really are, but yeah, it was a long day coming, and I'm sure it'll sink in here sooner rather than later.
Well, we've got 20, 25 radio stations. We're booming across here, across the 5-state region, and then of course we've got our social media audience, international, because I know we have a couple Canadian listeners, so I at least say international now. And I imagine you're going to be accepting more cases based on this if there's some sort of precedent. Are you going to be handling future cases like this? The reason I bring it up is you might as well take an opportunity to plug, some business right now, because there's probably a lot of people listening that may be interested in if they can go and, challenge the state. I don't know. I mean, a lot of mineral owners out there probably don't know if they can or not. So I don't want you to put your name out there and have to weed through 99 different people and tell them no just to get to one. Do you know what I mean by that? Oops. Hey, my dog is going.
Your dog, you can tell your dog to give a call if he's got some minerals. We'd be happy to help him out too. But no, I certainly appreciate the plug there. And yeah, we are taking cases, and I have signed up. Me, along with my firm and some of my colleagues here, have signed up several new cases and clients involving this very issue. And I'm actually at my desk without getting into the specifics of it. I mean, I've got maps of the KLJ survey out and the old segment maps from the Corps. And it's something that I think what we're really good at is, we've been on this since day one, so I can flip through the Corps maps, the KLJ survey, and we know the legal issues obviously very well on it. So we are taking clients, and if there's anyone interested out there, they're certainly welcome to give me a call at 701-237-6983. That's 701-237-6983, or they can email me at jswanson. That's JSWANSON, like the TV dinner, at Vogel Law, VOGELLAW.com, and I'd be glad to visit with them.